Maritime law, or admiralty law, evolved from the sea-based trading customs of Mediterranean civilizations. It regulated issues like contracts, salvage rights, and piracy. British maritime law became essential on the Atlantic crossings to America, where its administrative precision and terminology deeply influenced U.S. federal court language. English common law formed the bedrock of American jurisprudence. Originating after the Norman conquest of 1066, it evolved from a patchwork of tribal customs into a unified legal system. The laws of Oran, 12th century, France among the first written maritime codes adopted across Europe. Henry II, 1154 to 1189, transformed English law by establishing traveling justices and the principle of stare decisis, the doctrine of precedent. His reforms laid the groundwork for trial by jury and central court systems. The Magna Carta, 1215, imposed limits on royal power and protected barons from arbitrary imprisonment. Clauses such as key maritime influences on court language and procedure. Prominent contributors to common law. In admiralty courts, motions were formal requests submitted to a judge to take specific action, common in resolving disputes quickly on ships where efficiency mattered. The phrase "motion the court" reflects that tradition. It treats the court as a dynamic authority that must be activated by formal petition. This language carried over into land-based courts to structure proceedings with discipline and decorum. The docket. The docket was originally the ship's official ledger or log, recording cargo, crew, and daily activities. British Admiralty courts, 13th to 17th century specialized courts with jurisdiction over shipping, trade, piracy, and navigation. Even today, courts maintain dockets that track the legal voyage of a case through pretrial, hearings, motions, and judgments. Key maritime influences on court language and procedure. Motion the court. In rem, jurisdiction over property itself, e.g., a ship involved in a dispute. In personam, jurisdiction over a person or party. Maritime courts often seized ships, in rem, when owners were in foreign jurisdictions. U.S. courts adopted this distinction, especially in federal and property-related cases. The docket. The docket was originally the ship's official ledger or log, recording cargo, crew, and daily activities. Terms like pro se, habeas corpus, subpoena, libel, originally a maritime complaint, and interrogatories trace back to these early maritime practices and found a permanent place in U.S. legal vocabulary. Procedural uniformity and summary proceedings. In rem and in personam jurisdiction. American courts borrowed this procedural rigor, especially in pretrial phases and administrative matters, where judges can issue orders without full hearings, summary judgment, procedural motions, etc. In rem, jurisdiction over property itself, e.g., a ship involved in a dispute. In personam, jurisdiction over a person or party. U.S. federal courts maintain this tradition in admiralty cases, where judges often decide outcomes directly, reinforcing the image of the judge as captain of the legal ship. Use of formal, Latin-based language. Maritime law used Latin extensively due to its roots in Roman civil law. Federal jurisdiction over admiralty and maritime law is explicitly stated in Article 3, Section 2 of the U.S. Constitution. Procedural uniformity and summary proceedings. Lawyers emerged in ancient Athens, where orators like Demosthenes were hired to speak in court. Rome professionalized them as jurisconsults. The Inns of Court in London became the training grounds for English attorneys. Judicial authority without a jury. Prosecutors, representing the state rather than private interests, arose more recently and began appearing in 17th century England. Prior in medieval Europe, victims pursued justice. By the 18th century, in American criminal trials, the public prosecutor, a servant of the state's interest in justice, had taken a central role. Why this influence mattered in America? Early colonial ports like Boston, Charleston, and New York saw a heavy volume of maritime disputes. Federal jurisdiction over admiralty and maritime law is explicitly stated in Article 3, Section 2 of the U.S. Constitution. Montesquieu argued in the spirit of the laws for separation of powers, echoed in the U.S. Constitution. Locke, whose two treatises argued for natural rights, proposed that governments must protect life, liberty, and property, or be overthrown. Plato in the Republic envisioned law as a tool to mold virtue. Montesquieu argued in the spirit of the laws for separation of powers, echoed in the U.S. Constitution.